he is probably the most philosophical of my couple of thousand attorneys that do this work on why we do what we do. A great soul and a great family man and a fabulous technical attorney, my good friend Matt McClintock.
Thanks, Joe. I think I should probably sit down now. I'm not sure I've got my timer going here, so I want to make sure I don't run too long. Well, it's a great honor to be back at the Laureate Gathering. This is such a cool organization, and thanks to Joe and Steve and the SCI folks for letting me be out here one more time. This is great. As Joe said, I probably spend an inordinate amount of time thinking about trust protectors. It's no exaggeration to say that at some point every night I wake up with a new thought. And it's not necessarily a good thought. It's not, sometimes it's not even a productive thought, but this is on my mind all the time. Jeff's right, I need a new hobby. This is my hobby. I love it. As I started digging in to this notion of trust protectors, I've read everything I can find on this topic, whether it's Alexander Bove's excellent treatise, which I highly recommend to anyone, all the articles that are out there, every case that references protectors, trust advisors, third-party directed trusts. I really do get fascinated by this. One of the things that occurred to me is that as in my role as vice president of Wealth Counsel's education team, I get to interact with thousands of attorneys who practice all around the country. And I see, not only within Wealth Counsel membership, I also see attorneys that I interact with at the STEP conferences that I attend, NAPEC conferences, all these other conferences. A lot of people are talking about trust protectors, but they kind of talk about them almost in a one-size-fits-all mentality. They kind of look at it as the velour suit that the octogenarian might wear to the dominoes game. It's off the rack, it's nothing fancy, it's nothing special. And I think that the role of the trust protector is instead like a finely tailored suit that's for a special occasion. And that's where this title comes from, this bespoke protector. I believe that the role of the trust protector absolutely must be carefully tailored to the circumstances that a plan demands. But how do we start tailoring this? What are the limits that we can tailor here? Are there any patterns that we can follow? Are there rules that we should follow? And there are, and we'll talk about those in the time we have today. There's, just as a quick introduction to the materials, there are far more slides and materials than we're going to try to get to today. I really encourage you to spend time looking at those materials, getting to know some of the statutes. As Joe said, there's a big question mark about the role of trust protectors in California. California does not have a directed trust statute. And it's directed trust statutes that give us the room to play with trust protectors and trust advisors. I don't think that means you can't do them in California. In fact, I've got a lot of friends who do. But as Joe mentioned, a lot of times people will structure trusts in other jurisdictions that are more favorable, whether it's Nevada, whether it's Wyoming, South Dakota, Alaska, any number of states. And there is a growing body of states that have codified provisions for trust protectors, and we'll look briefly at those today. But there are all kinds of options you've got in how to use a protector. Lots of reasons why we would use those, certainly not the least of which is to build in flexibility to an estate plan. I don't even need to go over the agenda so much, but I have conversations with people like this all the time. I was talking with Kristen and Sharon a little bit earlier this morning. There currently is not a huge body of clarity in case law in the United States around what a protector is, what the protector can do, what the scope of their limits are and the limits of their liability, to whom they owe any duty, if at all. And this is the thesis that I am sharing with you today, that I think that if we fail to bring logic and discipline to the role of trust protectors, we're going to have some bad cases that are going to define that for us. And there are some bad cases already out there. And we'll look at those. But we're not going to like the results if we don't get our house in order around how we draft for trust protectors and how we act as trust protectors for our clients. This is a bit of a rhetorical question, I suppose, but I would kind of like a show of hands. I know a lot of you in this room. How many practicing attorneys in this room? Just a quick show of hands. Okay, great. Those of you who are practicing attorneys, are you using trust protectors on a fairly regular basis? Okay, a pretty good number use them on a fair basis. How many fiduciaries? How many professional fiduciaries in the room? Okay, great. I'm guessing that you guys see a lot of trusts come through these days with trust protector provisions in there. Okay, happens all the time, and it's happening more and more and more. As I think through the purpose behind having a protector, we certainly know the kinds of things protectors tend to do, and we'll look at some of the powers they often hold. But I think it really kind of comes down to this. The protector is somebody outside of the trustee, outside of the beneficiaries, outside of the settlor, who serves to represent the settlor's interests in the trust at some point down the road. Professor Stuart Stirk, who has an excellent outline that I believe was distributed with the materials, he gave me permission to share this. He's a professor at Cardozo Law School. He says that the protector is the living embodiment of the settlor. The notion is, of course, once the trust has become irrevocable, especially if our settlor is now dead, who speaks for what the settlor had intended? Well, Professor Stirk says that that's really the trust protector's responsibility. And I kind of see it as though the protector becomes the keeper of the settlor's legacy. They're the ones who make sure that what the settlor wanted to happen actually does happen many years down the line. Lots of reasons why we use protectors, certainly ensuring efficient administration of the trust, making sure we don't end up in court if we don't have to end up in court, making sure that the trustee is responsive to the beneficiary's needs, and again, really specifically ensuring that the administration of the trust carries out what our settlor really wanted to happen. But when we look at the trusts that we're seeing designed right now, and I'm designing trusts like this right now, where a protector has the ability to make significant changes to the legal effect of a document after the trust has become irrevocable. The ability, for example, to add or remove a beneficiary, or change the nature of a dispositive interest, or expand or contract a power of appointment, either for tax reasons, for Medicaid qualification purposes. There are lots of reasons why at some point after a trust becomes irrevocable, we've got to have a fresh look at this because circumstances have changed. The tax code may be totally different 2 years from now than the way it is right now. And if we don't have a back door to get into our trust to make modifications, we could end up with some very tax inefficient trusts. We could end up with trusts that are exposed to creditors. We could end up with trusts that cease to qualify a beneficiary for needs-based assistance due to a disability. So we need to have the ability to go back and look at a trust in a modification type of way. When we look at the types of powers that protectors hold, and just, I'm kind of breaking a little bit from some of the habits I will try to instill in this audience a little bit later today. When I use the term trust protector, I am using that as this general definition of someone who is a directed party who holds a power over a trust. We will later define those powers and hopefully kind of clear up some nomenclature. But when we look at the types of powers that are given, we can classify those certainly as affirmative powers, powers to do something, powers to add a beneficiary, or powers to approve a distribution, or perhaps even negative powers, powers to veto a distribution, power to maybe restrict some action inside the trust. But then we've got to look deeper beyond that. We've got to look at this underlying nature of the powers. Are these powers that are kind of quasi-trustee in nature? Or is there another classification, maybe a quasi-judicial type of power? And we're going to look at this. But this is where we start to get out our measuring tape and our scissors, and we start to tailor the role of the trust protector. We have to understand in the scope of the trust, why would we have a protector in the first place? What does the trust seek to accomplish that the role of the protector becomes appropriate? And we'll learn that as we look at the nature of the document and the nature of the strategy. For those of us, I'm also an attorney. I'm licensed in Colorado. The one of the things I think we've got to get really good at as advisors working with clients and as attorneys drafting documents for clients is getting really clear why the client is designing the trust the way they're designing the trust. Are we looking, for example, almost exclusively, I do lifetime long intergenerational dynastic trusts for people. Not because I'm dealing with clients with high net worth, but because I'm usually dealing with clients for whom the idea of family legacy is a really big deal. And they want to protect assets for multiple generations as long as those assets will last. So I'm a lifetime continuing trust kind of guy. But as I work with clients on these things, I've got to get very clear in a separate document, or maybe I embody this in the document itself, why are we creating this trust to last multiple generations? Because the motives behind the trust design need to inform how we shape the protector's powers. For example, if one of my clients says that for me, the preservation of capital, the preservation of a specific class of assets inside this family, that's a big priority for me, then the role of the trust protector is very different than if the purpose of the trust is to create as lavish a lifestyle for my children as possible. Those are two very different objectives for a long-term trust. But if we don't know that, how can the protector adequately exercise their powers? So we've got to look at the powers inside the document. This is a screenshot from a document assembly system that I use called Wealth Docs. Wealth Council publishes this, and I really do believe it's the best on the market. And this is just kind of a slightly modified language. You can read it in your own time, but within the body of my trust instrument, I say, why do I have a protector in the first place? But as we look at the nature of the protector's role, it's important that we start to recognize that the protector is not the trustee. There's something. What is the protector? We'll get to that a little bit, but we know it's not exactly like the trustee. So as we look at whether or not the protector is a fiduciary, one of the things we know that it's not synonymous with the trustee, because the settlor did not vest title in property in the name of the trust protector. They vested title in the name of the trustee. And so the trustee becomes the day-to-day custodian and manager and decision maker concerning the assets inside the trust. And they're the ones who are primarily charged with executing this trust in the first place. So then we have to look at the purpose of the protector's powers. And the primary function, again, I bring it back to Professor Stirk's comment, that it really is to exercise judgment on behalf of the settlor as this trust gets administered. And importantly, the protector's job is not to make the beneficiaries' lives easier. Not necessarily. It's not, the protector doesn't serve at the will of the beneficiaries. They shouldn't serve at the will of the beneficiaries. They should serve to advance the settlor's interest in the trust. Yeah, questions? Bronson asks a really important question. That becomes in the event of showdown between the trustee and the trust protector, who wins? And we're going to address that a little bit in this presentation. We don't have time to go too deep into that. The answer depends, as you might imagine an attorney might answer. Exactly, Jeff, and that's the way I am. Some of it is certainly going to depend on what the document itself says. We need to look at the underlying law to say which, in the event of a showdown, does the law point to something? Some jurisdictions do, some don't. And you end up with a difference between one jurisdiction versus the next. At the end of the day, the answer is the trust instrument should govern, but if the trust itself is sloppily drawn and we haven't really been very thoughtful in the exculpation clauses that we design, and if we end up, this is a conversation I had with Sharon before the break, before we started this morning, if we end up in a situation where, let's take this to the extreme, the protector The trust says the protector is never a fiduciary. Full exculpation clause, not liable for any acts whatsoever. The fiduciary, I'm going to pick on Northern Trust, the fiduciary, of course, Northern Trust would never work with a trust that's so poorly designed, but humor me. Then you've got this fiduciary, corporate fiduciary, Dunham, whoever, is serving as the corporate fiduciary, and the protector who says they're in a non-fiduciary capacity, no matter what, tells the trustee, you have to do this thing, and the act of doing that constitutes a breach. Well, now the trustee is absolutely caught in a bind because the protector can probably remove and replace the trustee. And so then what's the purpose of the trust in the first place? The purpose of the trust is not to protect the protector. The purpose of the trust is to carry out the settlor's intent for the benefit of the beneficiaries as manifest in the document. And the trustee's job is just trying to make sure all that happens. So this is part of the problem that we're dealing with right now in the industry, is that the law is generally silent on this, and people are all over the map as how they're designing these things. And as we get through this, I'm going to hopefully lay out a foundation for how we should be designing these things. Huge, huge issue, though. I'm going to jump ahead here a little bit because I want to make sure that we've got plenty of time to cover these things. One of the challenges that we deal with, if the protector is not a fiduciary, how do we know that protector is going to do their job when the time comes? Well, there are certain ways we could look at this. For example, we might say, does the protector have some kind of personal duty to the settlor? Or is there some moral obligation that is imposed on the power holder? Might there be market forces that are either in place or could be brought to bear to make sure that the protector acts in a certain way? Or are there legal liability rules in the form of fiduciary responsibilities? Well, when we talk about personal loyalty, what I mean by that is this relationship where the named trust protector is a family friend. Marty and I are friends, and so I could name Marty as trust protector of my trust, and although Marty may not necessarily have a legal obligation, because we're friends, he might feel this personal sense of duty to take care of my family in the role of a trust protector down the road. But what happens if Marty's gone? What happens if the person, the individual that I have named, is no longer able to serve when the time comes? Well, then there is no moral duty to a protector who doesn't know the family. Similarly, this notion of that's the personal loyalty, the moral duty really takes its origins in medieval times. I don't even know how to pronounce this word on the screen, but it arose when noblemen would go off to battle in ancient Europe, and they would leave their lands and their estate in the hands of the clergy. And so the clergy would basically operate in what has become the role of the trustee over time. But, ultimately the clergy is answerable to God. They've got a moral obligation to carry that out. Well, that simply that's not reality in the world that we live in anymore. Are there market forces that might be brought to bear? Well, I know that Jeff Dunham is going to be a very responsive trustee for me, because if he is not, there's a whole bunch of other trustees out there who will be. And so there are market forces in play for Northern Trust and for Dunham Trust Company and for Premier Trust and for all these great trustees out here, because if they don't do their job, they get fired. Well, in the event of a trust protector, there really aren't necessarily those types of market forces at play. We don't have, at least not yet, I think we can get there, but we are not yet at a place where there is a booming trust protector service company industry. There are a few organizations out there, but we're at the dawn of this era of trust protector services. So we don't have market forces in play like we have for fiduciaries today. One of the options I think we could get into, and this is something I'm exploring a lot, and this is one of the things that keeps me up at night, is, if the protector is the living embodiment of the settlor and the keeper of the legacy, can we impose a market force on them in the form of a contract that says that the protector is acting in furtherance of the settlor's intention to carry out the settlor's desires inside the trust? Maybe we can get there. The question then becomes, to whom does that benefit pass or that contractual obligation succeed to after the settlor dies? We don't know. But I think there's some things that we can do. Within the world of a legal liability framework, this is where we get into this whole fiduciary or non-fiduciary conversation. And the materials go into this in much greater depth than we've got time to address this morning. But we have to look at the nature of the protector's power, and we're going to spend some time camping on that this morning. But I think we also have to zero in on the fact that at the end of the day, the reason for having a trust protector is not to make the trust protector's life easier. The reason that we've got a trust protector in place is to make sure that what the settlor wants to happen actually happens when the rubber hits the road. And there's a lot of work that's involved with that. And we've got to make sure that at the end of the day, the beneficiaries inside the trust are protected. Here's my philosophy of the trust protector's role. The first thing is, because title is not vested in the trust protector, but vested in the trustee, you got to defer to the trustee's role. You got to defer to the trustee's judgment. That's why they're a trustee. They're the ones managing the assets or administering the trust. And they carry the bulk of the liability as a result of that. But the protector should intervene only when the protector believes, on independent survey, or perhaps is asked by an interested party inside the trust, hey, look into this, because I'm not sure that this is going on right. Whether the trustee has abused discretion or violated a fiduciary obligation. But we know, this is clear in the statutes that we'll look at, this is clear throughout the cases that we will look at, that the protector is not the same as the trustee. So I would argue then that the trust protector's duty is not the same as the trustee's duty. So they should not be the same. We shouldn't treat them in the same way. When we look at the body of domestic cases, and we're not going to focus a whole lot on that in the 15 minutes or so we've got, this nets it out. There's a significant body of domestic case law here in the United States where there was the role of a trust advisor, and that is a term of art that gets used in these cases, trust advisor. And the phrase that the courts keep coming back to is that the trust advisor is a quasi-trustee. It says that in the case law. And as we look at the mounting body of the Uniform Trust Code, which you do not have in California, we do not have yet in Colorado, but it's sweeping through the country. The Uniform Trust Code draws a distinction. Other states that have non-UTC derived directed trust statutes draw a distinction between the trust advisor and the trust protector. So I want us to start to think that these are not necessarily synonymous terms. The domestic cases say that a trust advisor is a quasi-trustee. You can go through these facts on your own. One of the takeaways from the Lewis v. Hansen case is that the settlor can basically choose where the trust is going to be administered. This is huge for folks like Jeff and for the people at Premier Trust and for all these other trust companies who are administering trusts for settlors in another state. Lewis v. Hansen stands for a lot of things, but one of the things it really stands for is that you do not have to be a resident of the state of the situs that you've chosen for your trust. Yes, you can be a Florida settlor, as in the Lewis v. Hansen case, a Florida settlor with a Delaware trust, with a Delaware trustee. You look to the intent of the settlor as embodied in the document. You look at where the trustee is administering the trust, and you look at where the trustee is domiciled. And those are the leading factors for determining what state law is going to apply to the interpretation of the trust. I'm just going to fly through these cases. Oh no, I want to camp on McLean for a second. because all the cases before this in the materials are trust advisor cases, where the trust itself appoints an advisor who has these duties that the court says are quasi-trustee in nature. And just as a quick spoiler alert for the materials, it's things like voting closely held corporate stock inside the trust. It's voting, it's directing the investment and reinvestment of trust assets, those types of things. And those are the types of powers that the early cases gave to trust advisors, and uniformly those are held as quasi-trustee, subject to a fiduciary obligation inside the trust. But fast forward now to the McLean v. Ponder case. It follows McLean v. Davis, I believe, was the first case in this series. And it's a tragic set of facts. We have a guy who became a quadriplegic following a car accident. Product liability case, and he got a settlement for, I want to say, about $2 million. Not massive, but significant. This guy's quadriplegic, significantly brain damaged, and his PI attorney worked with an estate planning attorney to establish a special needs trust or supplemental needs trust for Mr. McLean, and funded it with this settlement with the intention of this settlement hopefully will help him in his treatment for the remainder of his lifetime. Well, over the course of 18 months, the trustees drained the trust with $50,000 sound systems, with a very ornate fence that's put around Mr. McLean's modest home. They just are blowing through money like it is. Somebody used the drunken sailor reference. They're blowing money like the drunken sailor, Steve. And so Mr. Ponder, the trust protector in this case, ends up finding himself getting sued by the now trustee, mom of the McLean Trust, who she comes in and she looks at the books and said, "Whoa, what has happened to all my son's money? It's gone. Mr. Ponder, Mr. Trust Protector, what were you doing? Why were you not supervising the trustee?" Well, the very sad thing is that notwithstanding the fact that the trust itself specified that the protector's powers were held in a fiduciary capacity, the protector's powers were only these three that we see on the screen. The protector could remove a trustee and appoint a successor trustee, or resign as protector. So the question was the original trustee a corporate trustee or an individual? I believe it was an individual trustee. That's a good question. I've got to go back and look at that, but I'm sure it was. Because they're looking for any pockets that are deep enough pockets to help make this beneficiary whole. Because there's no question there was all kinds of crazy abuse going on. But what the trust said that although the protector's powers are held in a fiduciary capacity, the protector cannot be held liable for any action taken in good faith, and it specifically said he has no duty to supervise the trustee. But, Mr. Protector, isn't your job to protect the trust? That's what we hear all the time. It's an argument that's out there. The court says there is no duty to supervise the trustee, and we will not interpret one. So I'm sorry, at least Mr. Ponder, Trust Protector, you may go. You are not liable for the trustee's bad acts. And this is a bad result for a beneficiary. But it does say that although there is a fiduciary duty for the protector, mostly because the document said there was, the protector did not have a responsibility to supervise. Here are some of our facts. Yes, David. Yeah, good question. The question was whether on this last slide it says that the trust protector cannot be held liable for an action taken in good faith. That is, as to the protector's actions, the trustee is always subject to their own fiduciary standards as governed by state law and further refined by the governing instrument. One of the things that we see is that because there is no sweeping body of law yet concerning the role of trust protectors, we look to the governing instrument to define what the nature and scope of the protector's liability is. And this trust and many trusts say that they're not liable for actions taken in good faith, and there are some that actually are much more aggressive than this. The thing I want you to take away from this is, as it relates to the domestic cases, the trust advisor, as a term of art, was always considered to be a fiduciary. And the only case we have concerning protectors right now said that the protector is a fiduciary, but that's because the trust said so. Does this mean that those things are the same? And I submit that they are not, and we're going to look at the law. Heaven forbid, we're a bunch of lawyers in here. So, the growing body of statute out there in the United States concerning the role of trust protectors is the Uniform Trust Code. And the salient provision of the Uniform Trust Code is Section 808. It is titled Powers to Direct in the Uniform Trust Code. Now, you free thinkers out in California may never end up with a Uniform Trust Code. Hopefully someday you'll end up with some clear directed trust statute, and maybe it'll be influenced by this. But I want to kind of focus a little bit on these powers to direct, because I do believe they can be insightful. As we look at the nature of fiduciary duties, though, we have to recall that the role of trust protectors originated offshore. And not only are these international statutes, just a small selection of them, I have the entire pertinent part of the statutes in the back of the materials if you care to read these on your own. But even in the offshore magnet trust jurisdictions, they are not uniform in how they treat protectors. British Virgin Islands says that they are not a fiduciary. Cook Islands also says that they are not a fiduciary. Belize is interesting because it says that the protector is fiduciary to the beneficiaries or to the purposes for which the trust is created. Those are two different things. And I'm not even sure what the second thing means. But we're going to talk about that a little bit. I know you can't read this. I'm actually revising this slide for future presentations. This, and if you break out the magnifying glass, you can see this in the materials as well. But there is a suite of non-UTC-derived statutes out there that do address specifically the role of protectors and advisors. There are some that say that the protector is a fiduciary, or a party holding a power to direct is a fiduciary by default. Others say they're not fiduciary by default. Others still say the document can override the default in state law. And some just have bad statutes. I mean, Georgia's law is not very good on this. Indiana's law is a bit sideways. Utah's is really bad because although Utah adopted the Uniform Trust Code, they did not bring in Section 808. They've got their own asset protection trust statute, and that's where we see the reference to the trust protector. And it's like a throwaway comment. So Utah, we don't know what you can do in Utah as it relates to protectors. I do think our philosophy in here will hold, though. Under the Uniform Trust Code, this is the body of the language itself, and it talks again just broadly about parties who hold the power to direct. And within this statute, we don't have any reference in here to a trust advisor or to a trust protector. I'm going to jump ahead and we'll jump back. So in order to get to the language concerning trust protectors, we actually have to look at the comments under Section 808. And this is actually in the second paragraph under the comments. It says specifically in the comments that this section ratifies the use of protectors and advisors. It also goes on to say, and it draws a distinction within the body of the UTC right here, folks. It says that advisors have long been used for certain trustee functions. That's what all those cases in the materials talk about. Crocker, Hansen-Dinkla, all those cases that are in the materials and many, many more universally say that advisors have long been used for certain trustee functions. Scott on Trusts talks about this. That's just the way the law breaks out. But then we see a distinction start to get drawn here. It says that trust protector, a term largely associated with offshore, is more recent and usually connotes the grant of greater powers. So trust advisor, certain trustee functions. Trust protector, greater powers. So we're going to talk about what these greater powers are. But when we look at the Uniform Trust Code, we see Section 808 and we say, okay, well, that's interesting. It says that that a person holding a power to direct is presumptively a fiduciary. But if it's presumptively a fiduciary, does that mean that it is a fiduciary? Well, then we've got to look at Section 105 of the Uniform Trust Code, where what's called default and mandatory rules. And that gives us the ability to see how much can we tailor here. Do we have the ability to tailor this? So Section 105 says that except as otherwise provided in the terms of the trust, this code governs the duties and powers of a trustee, relations among trustees, and the rights and interests of a beneficiary. And the terms of this trust prevail over any provision in the code, and it goes on, except, and it's got this list of exceptions, but there's nothing about protectors or advisors. So what this says is that although under Section 808, third parties holding a power to direct are presumptively a fiduciary, if it's appropriate for the strategy, Section 105 says it doesn't necessarily have to be so. We can be really specific and a bit precise in how we tailor these things. Oh, and this also, the comments under 105 also support the Hansen v. Dinkla ruling, or the Lewis v. Hansen ruling, that says that the settlor's intent really carries the day. The settlor is generally free to override these rules and prescribe the conditions under which the trust is to be administered. So the settlor gets a fairly free hand, but that then becomes incumbent on us as practicing attorneys to help them create the strategies that make the most sense for them. Okay? So let's net this out. That party who holds the power to direct, this being a trust advisor or a trust protector, they are presumptively a fiduciary. But the settlor may override that presumption inside the trust instrument. Now, you can also have multiple parties with powers to direct. We've seen this through the bifurcation and separation of trustee powers, where we might have a directed trustee for administration purposes. We might have an investment trustee to manage the investments. We might have distribution trustees. We can break up trustee powers. Much the same, we can break up third-party powers to direct. There's no reason why we can't have a trust advisor or a trust protector. And I also think we can have a one-party trust protector, or whatever you want to call it. We can have one party who holds certain powers in a fiduciary capacity and other powers in a non-fiduciary capacity. We don't have to paint with one broad brush. We've got flexibility. This is from a trust I did recently. In fact, this is my own trust. And I have come to believe so strongly that we've got the ability to tailor these, that I've started putting this in every trust I draft when I include provisions for a trust protector. It says, first of all, that under state law, I was using Wyoming in this case, which is a UTC state, and so I said that under Wyoming law, parties to direct, trust protectors, are presumptively a fiduciary. However, under this other provision of state law, I as settlor can specify something to the contrary. And so then I say that some powers are given in a fiduciary capacity, others in a non-fiduciary capacity, and then I go out and delineate the powers. So this is no additional charge. You can rip that off if you want to. So as we look at the bespoke framework, these are in the materials. We're not going to go over all these powers here, but there are, again, common affirmative powers, common negative powers. But then as we look at categorizing these protector powers, I think we've got to be a bit smarter than just saying they're positive or negative, affirmative or negative powers. We've got to look at these powers and say, well, what kind of powers just look for all the world like the power we might give to a trustee? If we didn't have a protector, it's the kind of power a trustee would hold anyway. Well, the body of case law out there says that those are quasi-trustee powers, powers, again, to vote stock, direct investments, things like that. But then I would submit that there is another body of powers that I don't really think can be held in a fiduciary capacity, at least in the traditional sense of the word. Powers, for example, to add or delete a beneficiary from a trust. Because unless we really understand what exercising a power in the benefit of the purposes of the trust really means, how could I ever delete a beneficiary from a trust in a fiduciary capacity? I'm not quite sure. I'm not sure how I get there. If I, as a protector, say that, well, maybe we've got a very liberal distribution standard right now inside the trust, and now we've got a beneficiary who's got a massive spending problem, creditor problems, whatever. Well, maybe through the role of the trust protector, we've got the power to amend the trust instrument and kind of start to curtail some of those distributions to the beneficiary. Well, I'm not sure how I can really do that in a fiduciary capacity, at least as to that beneficiary, if I'm now restricting the money that they get out of the trust. Yes, maybe at the end of the day it's for their best interests, but that's going to be a kind of a hard hill to climb once you end up getting sued. So I think that if we look at these court-like powers, what I call these quasi-judicial powers, these are these powers that I'm not sure you can logically get there to hold these powers in at least a traditional fiduciary capacity. There's other material that I'm working on that did not make the cut for the slide deck, but I was talking with Kristen and Sharon again this morning about this. We also have to get out of our mind this notion that a fiduciary is a fiduciary is a fiduciary. It's not black and white. The whole world of fiduciary is not black and white. It occurs on a spectrum. And the reason I know this to be true is the SEC versus Charity case out of the United States Supreme Court case from 1943, where Justice Frankfurter says that to say that a man is a fiduciary is only the beginning of the inquiry. We have to then look to the nature of the powers, to whom a duty was owed, what are the consequences of a breach. So a trustee is a fiduciary, and they've got state law that defines their fiduciary duties. But not all fiduciaries are created equally. And that's what the SEC versus Charity case talks about. This is what I generally think of when I think of inherent trustee-like powers. You may disagree with these powers, and that's fine. You're entitled to be wrong. Totally kidding. You're not entitled to be wrong. No, I talk about this with other people, and this is kind of what we're coming up with, but I don't know that this is right or not. But things like, again, voting stock owned by trust, a whole body of cases talk about that. The power to direct or veto the sale of specific assets. You know, those are the kinds of things that, absent a party who holds the power to direct, the trustee could just do what they need to do. But there are other powers that I'm not sure the trustee could hold these powers because they're kind of these non-fiduciary type powers. Again, adding or deleting beneficiaries. We talked about that. Powers to construe the trust terms or powers to terminate the trust for some reason other than a diminution of assets over time. The power to remove or replace the trustee of an asset protection trust or a supplemental needs trust. Approving the trustee's compensation. Well, we know the trustee can't approve their own compensation. Resolving disputes among beneficiaries, modifying trust provisions, revoking or granting or expanding powers of appointment. Then there's this cluster of powers. I can't figure out where they go yet, and it probably doesn't really matter. Designating the succession of trustees, changing the governing law, changing the trust situs. Those, I think, are kind of non-toxic powers. It doesn't matter if they're fiduciary or not, because really anybody could hold those types of powers without any significant consequences. So when we look at the quasi-trustee powers, we're talking about powers that are tied to the ordinary day-to-day administration of the trust. Things like controlling the trustee's exercise of some discretion, whether it's over investments, whether it's over distributions, something that has to do with what the trustee does on a month-in, month-out basis. If the power has something to do with that, it's probably a fiduciary type power when held by the power holder. And again, the domestic cases here in the U.S. say that those are trust advisors who hold those powers, and that unequivocally they are fiduciaries. Then these court-type powers, these quasi-judicial powers, these are not like anything a trustee would generally hold. And again, I think that these probably can't really logically be held in a fiduciary capacity, at least in a very simple view of fiduciary powers or fiduciary capacity. I think we would need to tailor the fiduciary standard. So what do we do with all this information now? I think the first thing is, it's like the 12-step program, right? The first step is acknowledging you've got a problem. And folks, we've got a problem with how we are using protectors, and I think abusing protectors, and perhaps abusing our clients by not being really thoughtful in the role of protector powers. And we've got to be judicious, and honestly, folks, we've got to be realistic about the nature of the duties, whether they're fiduciary or not. And if they are, and are all fiduciary powers, again, created equally, or does this occur on a spectrum? We have to carefully review, and I believe we review this, folks, on a case-by-case, client-by-client, trust-by-trust basis, reviewing the trustee provisions, the powers given to the protector, the identity of the protector, the indemnification provisions for the protector, because the whole reason why we've got the protector in the first place is to be the living embodiment of the settlor, and our settlors are all different. And they've got different needs and different motivations behind the types of trusts that they're designing. So if we're going to have somebody be the living embodiment of that person 20, 30, 50 years down the line, don't we want that person's powers and exposure to be as tailored as the client would like it to be? I think we owe that to our clients. And I think we also have to make sure that we include mechanisms to police the trust protector, to hold the protector accountable for the actions that they take or the things that they don't do, like the McLean case. I don't want to pile on Mr. Ponder. He kind of got off, but it would have really helped Mr. McLean if there was some kind of mechanism in place that would have policed the actions of the protector. And at the end of the day, folks, isn't that what we're trying to do? Are we not trying to get the best results for our clients? We're not trying to get the best results for the protector. And we're not even trying to get the best results, I'm sorry, Jeff, we're not trying to get the best results for the trustee. I know, it's heartbreaking. We're trying to get the best results for our clients and for their family and for the legacy they leave behind, no matter how big it is or how small it is. We want that to succeed. That's the reason we're in this industry in the first place. And so, I hit this button too fast. One of the things I really like to do, and WealthDocs has this baked in as an option, is to allow the drafting attorney, at least as a safeguard, at least have the drafting attorney be able to appoint a protector or remove a protector. To say, well, I'm not going to be a protector of a trust I designed. I think I've got some ethical problems with that. And if time permits, we'll get to that. I don't know if we do or not. But I think that it makes perfect sense for the attorney to serve as the one who can appoint a protector once the need arises. So again, let's include the statement of the settlor's intent to inform the protector. So not to protect the protector, but to inform them. Why did we do this trust in the first place? Why did we design it this way? So then when the protector has to act, the protector knows that they can act in a way that carries out what the settlor wanted to accomplish. If we don't have that language in there, 30 years after our client dies, all bets are off as far as how effective this protector's role can be. Yeah? Yep. So just to kind of repeat the question for the recording, David raises an issue that we see this for any type of long-term trust. If you name the attorney Matthew T. McClintock as the one who's got the power to appoint, well, God willing, I'm not practicing 50 years from now. So maybe we name my firm, or maybe we name some other entity to hold the power to appoint. We name something that will outlive the individuals named inside the trust. So maybe we name the Vito Lanuti's law firm, the firm itself, as the one who holds the power to remove and replace, because Vito's going to be playing golf and sitting on the beach in a couple hours, yeah, about 15 minutes. But there's going to be somebody there who succeeds to his interest in that firm. Whether it merges, he sells it for $5 million, or whatever it is, something's going to survive the humanity of the person named. And I think you've got to create these mechanisms where you've got entities in place. We talk a little bit about who the protector, I was jumping past this, but I'm going to come back to it. So let's talk about who can serve first, and then maybe we'll talk about who should serve. Well, this is a bad slide, and I designed it to be a bad slide because I want you to scratch your heads here for a second. Conceivably, if the protector is a fiduciary, theoretically, someone who could serve as a trustee could serve as a protector. Problem is when we get into the scope of the powers. So for example, if the powers are limited to, for example, voting closely held stock, if you're in a fiduciary capacity, it really almost doesn't matter who serves in that capacity so long as they are a fiduciary. But we've got some really big issues with a lot of the powers we generally give. Section 2036, 2038, 2041, all these code sections will act to not only cause a state inclusion, but also in most states cause creditor exposure for the person who holds that power. So we don't usually want anybody who is related or subordinate to the settlor or to any beneficiary to serve in the capacity of a trust advisor or a trust protector, especially a trust protector, because the protector, I believe, in many cases will not be a fiduciary. When the protector is not a fiduciary, the types of things that we need to be thinking about as we name power holders is that if we select an individual, it needs to be one who is not an adverse party. It's a term of art in the Internal Revenue Code. They are not related or subordinate to the settlor or to any beneficiary. And related or subordinate is, again, a term of art taken from the Internal Revenue Code. It could be a committee of independent individuals. Perhaps it could be the attorney plus a CPA plus somebody else plus somebody else. That's a bad example because now you have an even number and who breaks the tie, but you kind of get my point. You can have multiple people. And then there is the beginning of a movement afoot, and Al King writes about this from South Dakota Trust Company, the use of special purpose entities, special purpose LLCs. South Dakota and Wyoming both have very good limited liability company statutes. I don't think that's a surprise to anybody. But they also have special purpose entity LLCs for the purpose of holding certain powers. The people are using these for their private family trust companies, and there are some companies now that are organizing for the sake of creating special purpose entity LLCs for the purpose of serving as a trust protector or trust advisor. So we end up with an entity instead of a named individual. Here's the reg section on what an adverse party is. It's basically anybody who's got a substantial beneficial interest in the trust. Not related or subordinate, we don't need to go over that. So when we look at who ought to be a trust protector, maybe we just name our brother-in-law. I love my brother-in-law, he's a great guy. Not a very good option for a trust protector. He's a tech guy. What does he know about trust administration? So as good as the brother-in-law might be, he probably lacks the sophistication, probably lacks the objectivity to serve as a protector for my long-term continuing trust. And again, to David's point, if I name my brother-in-law, well, one of these days he's going to die. And so then what? Do we name a CPA? Do we name a financial advisor? Maybe, but again, we've got to make sure that they've got the sophistication and objectivity. Do they also have the disposition to serve in the capacity of a protector? And will their will their insurance carrier allow them to serve in that capacity? I think that's another legitimate problem. Maybe it's another experienced trust and estates attorney. Again, I could name Marty. Marty knows what he's doing with the role of trust protectors. I could name Kevin Forbush as a trust protector. These guys, Vito, all these folks in here, they would be excellent, excellent choices if they're willing to serve. But again, naming an individual only goes so far as that individual. And maybe I give Marty the power as trust protector to appoint his successor. And maybe I say that in considering his successors, he should be looking for people that have these qualities. Other experienced trust and estates practitioners. And so, I mean, Marty is a longtime member of Wealth Council, member of Elder Council, and so Marty has access to thousands of attorneys around the country. And he could say, hey, Vito, I'm going to be resigning because I just want to go fly my plane and go see my grandkids all the time. Vito's going to say, well, I would love to, but I'm on the beach drinking a Mai Tai, so maybe I'll ask Steve. Well, no, can't ask Steve because Steve's fishing up in Jackson Hole, but we'll find somebody because you know thousands of people. And I got to wrap it up, but here's a big problem. I'm going to leave this with you. This is going to be your nightmare for those of you who are practicing. Should you, as the drafting attorney, serve as protector for a trust you create? Well, again, I think we have seen that not all powers are created equally, not all duties are created equally, and some powers probably cannot be held, at least in a traditional fiduciary capacity. But what about your fiduciary obligation as attorney to your clients? There's another outline. I don't have time to get into it right now. I believe it was circulated with the materials. If not, I can distribute it to you. But you've got an inherent conflict of interest. If you're the drafting attorney and now you are administering, not really administering, but you're serving as protector. Sorry, that's my timer. It tells me to shut up. I'm trying. But if you become party to a suit because you failed to exercise a power as a protector, I mean, you're in a double bind now. The drafting attorney should not serve. I do believe this argues in favor of a strong network of colleagues who are willing to go there and serve as protectors. And again, I'm out of time, but I would encourage you to spend time with the materials. Again, I intentionally stuffed the materials chock full of goodness for you. That's all the time I've got for today. I'd love to stick around and chat with folks in the halls because this is something I'm passionate about. And Jeff, I promise I'm going to try to get another hobby. Thanks for your attention. It's been great to be here with you this morning.